This is The Law Matters. Of course it does. Welcome once again. I'm Debbie Morais, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, some practical assistance on various issues that will affect you and your life. As we tell you, the law matters, and a better understanding of the law puts you in a better position to decide how to protect yourself, your family, and at times your business. As we present various topics, our goal, of course, is to help you if you should decide to handle some issues yourself. Of course, you may decide to seek outside professional counsel. Our goal is to help you be prepared and to save time, results, and achieve the best possible results. As always, we want to welcome again and thank Attorney David Bazar, who continues to weigh in on the various topics that we present.
Thank you.
And today, we're going to discuss probate, what it is and how it works. Why is it necessary, and when, and what happens if there is a will versus what happens when there isn't one? At times, it seems that you could actually end up having your estate pay more, have it cost more if you didn't have a will. Imagine that. So if you don't plan for your assets, how does that play out? Our goal today is to help you have some key takeaways so that you can plan going forward. And even the matter of guardianship. How does that affect one's estate and one's family after you pass? So let's get right into it, David. Basically, what is probate and how does it work?
So probate court is different in every state. It's a state court, so the rules of each state control what happens in probate court and actually even where probate court is. We'll concentrate mostly on Rhode Island, but we can show some of the differences. In Massachusetts, the probate and family court, as they call it, is really basically a county by county court situation, whereas in Rhode Island, probate court, which is different from family court, is really a city or town by city or town courthouse.
Okay, and probate applies to someone who has passed.
Jurisdiction of probate court will also vary somewhat state to state, but generally speaking, probate court will cover someone's death and administration of their estate or the assets that are in their own name at the time of their death. It will cover guardianship for people who are alive but cannot either legally or physically or mentally make their own decisions, and then various other things such as name change and that type of thing.
So when we talk about what your estate is, what your assets are, it might be cash, but of course there are other things. Most people think immediately of their home. What else might come into play that would be an issue for the probate court to consider?
So if somebody dies and they have property in their name and their name alone, not joint with somebody else, not subject to a beneficiary transfer or transfer on death, then those assets would be subject to probate. That's how we transfer our wealth or our assets from us to whomever they're going to go to next. And the types of assets that are going to go through probate court, generally speaking, as you said, would be real estate. Any real estate that's owned in just your name, not joint with somebody else, or owned in your name as tenants in common, meaning that you own your own share and your person or people that you own the property with own their share. So your share has to be transferred. Bank accounts, investment accounts, retirement accounts that don't have a beneficiary named on it, for example, life insurance that doesn't have a beneficiary named on it, automobiles, those types of things. Anything that's in your name that doesn't have either somebody else's name or a beneficiary named will then be subject to transfer through probate court.
Okay, and who is taking care of those things? If there's a will, what's the name of the person who's taking care of that versus when there is no will? What do they call the person who is taking care of that, and what is their role?
So the person who is the fiduciary or responsible person for carrying out the intentions stated in the will is the executor or executrix. It's Latin for, male or female or whatever, or without a will, an administrator or administratrix.
And if you have a will, you choose who your executor is. If there is no will, an administrator hasn't been selected by design, I guess. So that would mean who is selecting who the administrator will be.
So the whole reason to have a will is, first of all, to pick who you want to be in charge of the transfer of your assets and the settlement of your estate, and where you want your assets and estate to be transferred to, who are the people or charities or wherever it is you want your things to go to. And administration is based on state law, so somebody is going to petition to be the administrator or administratrix of your estate, and the petitioner can ask that they be appointed or that somebody else be appointed. The court will look at what's the relationship of the person or people who are asking to be appointed to be in charge of your estate, but then the state laws are going to control where everything goes.
Is there ever an occasion where someone's estate, however little, wouldn't be part of probate?
So if you have assets in your name and the assets are less than, in Rhode Island, $15,000, then you can transfer those assets by what's called an affidavit, and it depends if there's a will or not, but it's an affidavit of small estate or an affidavit of voluntary petition for administration, or a small estate for a voluntary petition for probate of the will.
So you mentioned that you can avoid some issues if things are in joint. So say a house is jointly owned by a husband and wife, a bank account is owned jointly by a husband and wife, the car is owned by the husband and wife and perhaps the bank if there's something owed on it. If all of those things are jointly owned by a husband and wife, could they easily say, I don't have anything to worry about?
There's always something to worry about, and as lawyers will tell you that there's always something to worry about. And in fact, we'll tell you what those things are that you might worry about. However, two things. Yes, in the sense that if you're joint husband and wife, tenants by the entirety on real estate, that's going to pass without probate. If you are joint on a bank account with husband and wife or anybody else with right of survivorship, it's going to pass without probate. And I qualified it a little bit because an automobile, generally speaking, you just own that yourself. But if you do have a spouse, then there is a statute where the registry can transfer it from the spouse who died to the spouse who survived without the necessity of probate.
And if husband and wife jointly own just about everything, and then there's a child, is there a chance that that could still become a probated or a contested issue because the child may feel entitled or want to press the issue that, for whatever reason,
okay,
so they want to move that in that direction to cause a little trouble or just have something?
First of all, let's talk about how old the child is.
Okay.
Because if there's a child that's a minor, then there's also the issue of who is going to have guardianship of that child. Not an issue if there's a surviving parent, but if there's not a surviving parent, which is one of the reasons we always suggest to have a will, because we would then get into guardianship of a minor if there is no will and no surviving parents. So we'll put that aside because we'll talk about guardianship later. If a child wants to contest a will or assets that are going to the spouse, that's not going to happen if the assets are all joint, because it's not going to go to probate. So there's nothing that the child can contest. If there are assets that are going to probate and there is a will and the child wants to contest that will, well, there's language that we generally put in a will that would take care of that, which is a contest clause that says if anyone contests the will, then they're automatically out anyway. If it's a probate by administration without a will, then the child actually is going to have some significant rights because everything by state law, at least in Rhode Island, does not automatically go to the spouse.
Okay. I know that there's a saying, there's no escaping death or taxes. So when one has happened, namely a death, there are always taxes. If there is an issue about tax, everybody's debts have to be paid. There's always an issue about taxes. What in this situation, can you briefly tell us, well, I know it can be very complicated, well, could you briefly tell us about what goes on with death taxes?
Okay.
What kinds? How much? How do you avoid them?
So estate taxes are due, and an estate tax return is due even if there are no estate taxes that need to be paid in many situations. So we talked about the surviving spouse with the real estate and the bank accounts and all of those things, and there's no probate, but they do own that house together, and it was tenants by the entirety, so it's automatically going to the surviving spouse. However, and we're going to talk about Rhode Island, there is an inheritance tax lien on the property on the death of that first spouse. And with a surviving spouse, no matter how big the estate is, there is no estate tax between husband and wife because there's a marital deduction that would, if it's all going to the surviving spouse, that would take that full deduction in place. However, if it's a big estate, you would have lost the opportunity to save estate tax on the second death when there is no longer going to be a surviving spouse. And oftentimes we do that through a trust plan where we create a family trust and shelter in Rhode Island the $1.7 million or so that the first spouse is entitled to take as an exemption, and then have the $1.7 or so million exemption on the second death as well. You have ability to plan for that if you do it while both the spouses are alive, but in any event, even in that first situation where there may not be any estate tax due, since there is that inheritance tax lien on the property, we have to file the estate tax return and let the state send out we create a T-77, which is an estate tax lien release that gets filed on the record of land evidence so that the tax lien's removed.
What about federally?
Federally, right now, it's almost 13 or maybe even a little more than $13 million for each spouse, so $26 million, which is portable. The Rhode Island estate tax deduction or exemption, you can't move between spouses. The federal one you can if you file on the first death, so the spouse can claim the remainder on the second death. That is going to go away in 2025 if no new legislation is passed federally. The reduction will probably be with inflation to around $6 million that year. My guess would be that although they compromised on a debt ceiling, so maybe they can reach a compromise on what it might be, but I'm not going to hold my breath to say that they can do that. So if they don't do that, we'll be back to the old law with the inflation increases, which I think should be around $6 million, give or take.
And of course, we're talking about somewhat large estates. At the beginning of this segment, I mentioned something about sometimes it could be costlier if you didn't have a will. Apart from the aggravation or that people just want to avoid discussing death because it's not fun, how much it costs for a lawyer to be involved. Comment, if you will, on how it could be actually worse if someone didn't go through the process of planning for their will or their trust or whatever.
Yeah, the planning, we call that a gift to your family to do that, because you can make sure things are handled the way you want them to be handled. So if you have children, you want to make sure that the property eventually gets to your children perhaps, or perhaps you want to make sure it doesn't get to your children or not to all of your children. So the best thing you can do is to sit down and have a discussion with a lawyer to tell them what your concerns are, what your goals are, what you want to accomplish. So a plan can be put in place that carries out what you want. Who do you want to be in charge of how your assets are distributed? Where do you want them to go? Is there a charity you want to benefit? Do you have a spouse that you want to make sure is taken care of? All of those things are really important to plan for death. And it's also equally important to plan for living, but perhaps becoming incapacitated.
So those things take planning. A person who's the executor of a will have work to do to make sure that these things are taken care of. The person who is an administrator, if there's not a will, would have things to be taken care of. knowing, as you have just laid out a few of them, that there are filings, legal documents, tax papers, I don't know if there are hearings, if there's transferring of titles, is that something that the executor or an administrator would likely be able to do on his or her own, or would they need to automatically enlist a lawyer to do that?
I think the best way to do it is to hire an attorney who's going to be able to help you settle the estate, as we call it, because when you open up a probate, you have to file, when you close the probate, a notice that there's either the estate tax has been paid or that there is no estate tax due. So that requires filing a form in Rhode Island called 706, which is the estate tax return. It can be complicated. Depending on how much it is, it can be lengthy. And you really want an attorney to do that. So what we do when we help an executor or a trustee settle an estate is we make sure that all of the assets are gathered. We help claim all the assets so that they're either in the estate or in the trust. We make sure that when the assets are distributed out to the beneficiaries, there's releases signed so that you have both a release of the executor for internal purposes, we do that, but also for probate, if there's probate, to make sure that those releases are available when you go to close the estate. There's a lot of things that go into the proper settlement of an estate, and so my recommendation would be to hire an attorney to help you with that. If you want to do it on your own, perhaps you're an accountant or have ability to do those estate tax returns, but I wouldn't do it on my own.
Is that a pay me now or pay me later, or perhaps
it can
both?
Be, yeah, or come help me straighten it out.
Which could be even more costly if it's not done properly. How long does it take for an estate to settle if it is in probate without dispute versus when there is a dispute?
Yeah, so if there's a dispute, it can drag on for some time. Typically, without a dispute, you file the initial petition to open the probate. There's a period of time where creditors can make claims, which is usually 6 months after the probate has been opened and the executor has been appointed, so that, or administrator, so that the creditors could file claims with probate. That's a whole nother reason to have an attorney, because some claims are legitimate, some aren't, so you might want to deny those claims and fight them if you have to. Once that 6-month period's gone by and all the assets have been claimed and you filed the estate tax return and you've gotten the either no tax due or the closing letter from the state, then you can close the estate. I usually advise that it's probably a 9-month process without disputes. It could be a little bit shorter, but that's generally what I would advise.
Address, if you will, the idea that while probate is going on, there's a widow or widower, there are children. How is an allowance addressed? What are we living on in the middle while all this is in dispute, or if not in dispute, just not resolved?
If necessary, there's a statute that allows a widow's allowance or an allowance to be sort of advanced, if you will, or paid out, so that money is available to cover bills and expenses. Generally, if it's an undisputed situation and there's a spouse, usually it's like you said at the beginning, you're going to have a joint account, so there's going to be money. But if you need to claim in Massachusetts and Rhode Island both a widow's allowance, that's absolutely available and can be done.
And good for someone to know if they didn't. When there's a trust, the person who is going to take care of business after one passes, they're allowed some money, I guess, to take care of that. Would you address that as opposed to when there's a will and an executor or an administrator? Does anyone have a fee that's
So when there's a
levied
trust, the trust document itself lays out the role of the trustee and who the trustee is going to be. On the death, you'll have powers of the trustee to create what's called an administrative trust generally, which is gather up all the assets that were in the trust. That if it was a revocable trust, it now becomes an irrevocable trust, and a new tax ID numbers received for that trust, and then that trustee can immediately get the money into the trust and use it to pay bills, give advances if necessary, make transfers to the beneficiaries. There's no oversight from a probate court judge. You don't have to get permission to do anything if it's like you would in administration. You're able to administer the trust without the red tape of probate court. And that's why you have to be careful that you pick someone who you trust to be that administrative trustee, and who's going to be able to either hire an attorney or do what needs to be done to move that along. And it can be moved along very quickly.
And if there's an executor, I suspect many who've not done it before have no idea about what they're getting into and what needs to be done. We should go through that in a minute. But is there an allowance for them too, or some percentage or a fee or something that they would extract, just as a lawyer would need to charge for his services if he has to gather those documents, file the documents, etc.?
So the trust, as you asked initially, will generally have language in it as to what a reasonable compensation can be paid, or if it can be paid at all. Most trusts allow a trustee to be compensated for their time to be able to administer the trust. An executor can also be compensated for their time. Generally speaking, it's not a percentage. It's usually based on the time spent at a reasonable hourly rate that will then usually have to be approved by the probate court.
Probate judge, probate
judge.
Court. Let's talk about, apart from the financial side of it, well, actually part of the financial side, when there is a child, a minor, or one who just doesn't have the capacity or the ability to take care of himself or herself. We broach the subject of guardianship as something someone could take care of with a will. Let's talk about that a little bit. There could be someone who takes care of the child cares for versus financial. Explore that if you will.
So usually when a young couple comes to an attorney with the money issues and the questions about who's going to be the executor of the will and that type of thing, the question will come up, if there are young children, who's going to be the guardian of the children, and who is going to be the trustee for the money that's going to be held for the children, and on what terms. They don't have to be the same person. The guardian, as you've said, is the person who's actually going to take physical care of the children. The trustee is the person who's going to take care of the money for the children and make sure that they have what they need financially. So you would, as an attorney, go through who are the people that you would want to take care of your child if something happened to both of you, if there's two of you. Obviously, the surviving spouse would be the one, but if there isn't, and who's the backup? Let's have a backup for that, and also for the trustee. And at what age do you want your children to get their money outright? Or do you want them to get it in stages? Some at 25, so they get a chance to understand that when you get money, you can blow money fast. Maybe at 30 and a little bit more, and maybe at 35 the rest. There's a lot of flexibility when you plan for these things in a will.
So you were talking about a trust and a trustee who might take care of the finances versus having a guardian who cares for the child. If there's a will, not a trust, there's just a will, the lawyer would be sitting with the couple if the bus hits both of you and there are children. What happens then as far as the person who would be selected to take care of the money portion versus or in addition to the care of the child? And are those two people perhaps the same, perhaps not? How is that explored?
Yeah, so what I was actually talking about was a will.
Was the will.
And the trust is in the will. The will creates the trust, therefore it's called a testamentary trust. And so those are the things that I was describing when I was describing that trust. If you have a separate trust where you already created a trust, that would be different.
Good distinction, good to know the difference. How do you go about selecting who the guardian might be? Maybe it's not the next of kin, although somewhere that might logically be an answer, at least for the caring of the child versus the guardian. And what happens after, if it's not an issue about it being a minor child, but one who has some special needs?
Okay, so first of all, I always tell people, sometimes they'll come in and they'll say, you know, I would like my wife's mom to be the trustee, but she's older. But I say to them, is that who you want right now if something happened to you today? And is it likely that's who you would want for the next 5 years? And if the answer is yes, they say, then pick that person. If you 5 years from now are uncomfortable with that, you can change it. You can always do a new will or a codicil or whatever you want. We usually just do a whole new will at this point in time. But the answer is pick the person that you would want to do it if it happened today. And make sure that you're comfortable with that person and a backup for that person. And as far as the trustee, same thing. Who would you want to be managing the money? So can it be a relative? Sure. Can it be a friend? Of course. Whoever you think your child will be most comfortable with and who will be best for raising that child.
Makes sense. And let's back up just for a moment to say, so whether you selected a trust, someone to handle the trust, or you selected an executor for your will, number one, if you're working on this as a lawyer for a couple or person or whatever, do you suggest that they notify the person who's going to be the executor where everything is, or that it's being held by you? Should the executor have a copy of it? And then when someone dies, what should happen first? What should that executor do?
So two things. First of all, when we do a plan, whether it's a will plan or a trust plan, we generally have a binder or a notebook that has everything in it, and we tell our clients, don't lock this away, have it in a place that it's accessible, and whoever the people are that are going to need it at any point in time, tell them where it is. So that's number one. Number two, what the executor should do is upon the death of somebody where they are going to now be in charge, they should contact, in our case, we have our phone number and everything in the plan, on the book. They should call and say, what do I do next? That would be the first step.
So whether it's a will or whether it's a trust, either way,
Yep.
I imagine that someone needs to not disturb property and needs to let the banks and everyone know when you go through that step by step with someone.
Right. So what happens, obviously, when someone dies, usually the first person that gets contacted is the funeral home. And the funeral home will, if there's Social Security, contact Social Security and let them know. So that's step number one, that's done. Step number two is that after the funeral and everything's settled down, you contact the attorney, and we generally, if it's us, will make sure we contact everybody else that needs to be notified. And that's part of the role we'll play.
Good to know. And one other practical issue, so many things are available online, David, and you as a lawyer go through all of the what ifs and if onlys that people can't consider. Do you ever advise that they look online first to have an overview of some of the questions that you're about to ask, so they will have had at least a head start on thinking about what decisions might need to be made, not that it doesn't fall in your court ultimately to finish it up? Does that help, or is it not worthwhile?
Well, if they don't want to do that, when someone makes an appointment with us, we'll send out a form with all of the information they need to start thinking about. So we'll do that. But if you want to do that on your own, you certainly can do that. You know, the planning process isn't about the documents, because you'll see advertisements like you get this will for $90 or whatever, or trust or whatever. It's the advice that goes along with it that's the most important role the attorney plays. So sure, you can get documents online, but it's not the advice that you need to make sure what you're putting into those documents is correct.
Thank you. We thank you for tuning in for this review of all things to do with probates and wills and guardianship. Thanks for the strategy and the logistics. Thank you for tuning in to The Law Matters. As we say, it matters to you.